So this panel, this discussion is about asking who's responsible or who should pay for the consequences, the death, damages, and destruction from human-caused climate change. And if you read or read perhaps New York Times Magazine, you saw a big magnum opus earlier in August where the critically acclaimed novelist Nathaniel Rich said it's all of us, and that we all collectively, ourselves, are responsible, and that human nature is to blame. Oops, the Berkeley hiss. But some other folks have got a different idea, including the city and county of San Francisco, actually 12 jurisdictions across the country, from Boulder, Colorado, to the state of Rhode Island, to the city of Baltimore, to King County, Washington, have now filed lawsuits against the major oil and gas companies, saying that they, in fact, are responsible, that they have a disproportionate share of culpability, that they should pay some of the costs of the loss and damages associated with climate change. And that's what we're going to be talking about today, is those cases and how they all work out. And we've got a really great panel of folks here to walk us through both the legal angles, the scientific angles, and then sort of the grassroots popular civic angles of all this. We'll have a conversation with these folks for about 60 minutes, and then we'll open it up for questions, comments, statements, polemics from all of you, and so that we can have a real discussion. So who do we have here? This is Dr. Christina Dahl. She's with the Union of Concerned Scientists, who's been organizing all the activities here today, and she's the senior climate scientist in the Climate and Energy Program there at Union of Concerned Scientists. Yvonne Murray is with the City Attorney's Office and the City and County of San Francisco, and she's got a fantastic title. It is Senior Attorney for Complex and Affirmative Litigation. Did I get that right? So not simple and passive litigation, complex and affirmative litigation, and she's been among the attorneys handling the city and county's lawsuit against the major carbon polluters, and she'll talk about that. Stephen Feit, he's with the he's a staff attorney with the Climate and Energy Program at the Center for International Environmental Law in Washington, D.C. He'll also explore some of the legal angles outside of the lawsuits here in California. And then May Boovy is the executive director and one of the co-founders of 350.org, which I hope needs no introduction among this room, which of course is the grassroots international climate movement demanding bold action on climate change. So thank you guys all for coming here. So Yvonne, let's start with you, because you've been handling one of these cases. So I guess the question is, why exactly did the city and county decide to sue these major carbon polluters, 5 of the largest oil and gas firms, and demanding compensation or restitution for climate change impacts?
San Francisco is a coastal city, as you all know, and coastal cities across the country are going to be subject to the now irreversible consequences of global warming. So it's not a question of whether or not San Francisco needs to be reimbursed. We know there's going to be damage. We know sea level is going to rise. And we know that San Francisco is going to have to take action to prevent and to adapt to those changing conditions. And so San Francisco has 2 choices. One is to pay for that damage. But it's damage that San Francisco in and of itself didn't cause. Right, fossil fuel companies. It is pretty. It's an agreed upon principle that fossil fuel companies are the primary sources of greenhouse emissions, and that they are significant contributors to global warming. So the law is many things, but in some ways it's crude in its remedies. Right, lawsuits can bring you change to things, and it can bring you money for things, and that's kind of about it. So we as lawyers need to think we have a problem. San Francisco didn't create it, but San Francisco's going to bear the effects of it. So the question is whether or not San Francisco should have explored holding those who are responsible or who are chiefly responsible for those conditions answerable. And we clearly chose yes, and that's why we filed our case. Now, my boss is Dennis Herrera, and he is a man. He's a city attorney of San Francisco. He's a man known for being bold. He's held office more than 15 years, and he has been at the forefront of our marriage litigation, our challenges to the administration, and he takes cases that he believes are right and just. And we don't always win out of the box, and here we did not. We were dismissed in our climate change complaint by federal judge William Alsup. We are on appeal. We feel like this is a righteous case to push forward. We are not alone. We filed our case with the city of Oakland. As you said, there are many other cases across the country. But at some point, you have to ask yourself whether or not something is so important and will cause a city like San Francisco such cost and damage, whether or not it is worth it to try to hold those who are responsible to answer for the conditions that they created. That's kind of a long way of saying that's why we filed.
No, that was a great answer. Thank you so much, Yvonne, for sharing that. We're going to come back to in a little bit, like the actual particular, the practicalities of how and sort of the legal doctrines of your case. But let's talk about the damages. And so, Unit of Concerned Scientists, you all published a report called "Underwater: Rising Seas, Chronic Floods, and the Implications for U.S. Coastal Real Estate." And I wonder if you could talk about what that showed and how it relates to cases like those from the city and county of San Francisco, city of Oakland, and some of the other California municipalities. It also includes, right, there's other cases, County of Marin, County of San Mateo. So what did you all find when you looked at the consequences of rising sea levels?
Sure. So we first started looking at sea level rise as an issue and a threat to our country. We started looking at about 5 years ago in terms of really dedicating research energy to it. And when we started to do that research, we came at it with the attitude that a lot of people have towards sea level rise, which was that it was going to be a threat that we really wouldn't be truly facing until much later in the century. And the more we started to dig into the data, the more we realized that long before our homes or roads are underwater with every high tide, they're going to be experiencing much more frequent nuisance level flooding. So this is, you've probably seen pictures of this. You know, Miami Beach is sort of the epicenter, and that's the place that makes the news all the time. There are places here in the Bay Area where every time there's an extra high tide, maybe at a new moon or a full moon, there are stretches of road that flood. So we started to really want to quantify how extensive this flooding would be, how frequent it would be, and how disruptive it would be in the near term. So in our most recent report, you can see some results here. What we're showing is the number of homes that are at risk of flooding chronically. That means flooding on average every other week due to sea level rise by the end of the century. And so these are the places that have filed lawsuits. The city of San Francisco by the end of the century would be looking at over 4,000 homes at risk of this chronic flooding, whereas places like San Mateo County, we're looking at over 30,000 homes at risk. So this is an enormous challenge. Nationwide, we found that by the end of the century, there are almost 2.5 million homes at risk of this chronic flooding. And the total dollar value tops $1 trillion when you look at it all together. So that really does come into play when we think about how we're going to prepare for this enormous nationwide challenge. It's going to take a lot of financial resources. And so it does beg the question of where is that money going to come from? Right now, essentially, we all as taxpayers are sharing that burden. And so it's a fair question to ask whether, as Yvonne just said, those who are most responsible for producing those greenhouse gases should also be held to account.
It's really interesting. I just did a story for The Nation magazine. There's some copies out there. And I was talking to Sheldon Whitehouse, the senator from Rhode Island. He said, this stuff is really going to come to a head when sea level rise starts to intrude on the horizon of the 30-year mortgage. But like we're already there in some places, right? I mean, the 30-year mortgage is whatever, 2048. And so this I mean, what about other homes in other places that are not on this map? Yeah, like Broward County or Florida. How many homes there?
Absolutely. In that 30-year time frame, we specifically looked at that because we wanted with real estate, you want some sort of time frame that people can really wrap their heads around. So we chose the 30-year mortgage time frame. And just in that time frame, there are over 300,000 homes at risk that are today worth a collective nearly $120 billion.
So it's one thing to say, okay, global sea levels are rising due to anthropogenic causes, and we get that. But then it's another thing to connect the dot and say these companies are responsible. So Stephen, your organization, you guys put out a report called Smoke and Fumes. And I think following up on some of the work that had been done by Inside Climate News and the Los Angeles Times and others with these Exxon new revelations. So what did you find, and how does that help kind of connect the dots between saying, okay, there's this harm, but is there really a perpetrator that we can point to?
Sure. So if you don't know, for the past 5 or so years, CL has been trying to do research to answer 3 basic questions. What did the oil industry know about climate change? When did it know it? And what did it do with that information? And we could spend a lot of time going into the timeline, but there are 5 key takeaways. First, spoilers, they knew. They knew early. They were doing active research into climate science at least as early as 1957, but it wasn't isolated. They continued to do that research both through their individual companies and through coordinated industry research organizations, to the present day. But then in addition to just the climate research, they also had the necessary expertise to understand the context and the importance of what they were seeing. They researched hurricane formation and forecasting. They looked into paleoclimates, historical sea levels and carbon concentrations in the atmosphere and the way that those interacted with historic temperatures so that they could find oil offshore because they needed to know where it developed and where it was. They were extremely, extremely coordinated, more than any other industry except maybe tobacco, which was modeled after oil. They operated as a unit. It's not that they didn't compete at all, but they really understood that the importance to their bottom line was to collaborate against regulation rather than to fight each other over a little market share. And you can see this in internal company and industry documents where they are talking about the need and the imperative to share information and to join communal pots of money to fund research as opposed to doing it all on their own. So again, they're all coordinated, a lot of expertise, knew about climate change. They also knew of the alternatives, the ways that we didn't have to go down this path. They, since the 40s, were studying carbon sequestration from gas streams, originally for enhanced oil recovery, but also, notably, they acknowledged it could be used to remove carbon dioxide from gas stacks and exhaust pipes for the purpose of mitigating climate change. They were looking into solar patents. By the end of the 70s, basically all the US solar industry was owned by the oil industry. And we know what happened with that, very little for a very long time. They were looking into electric vehicles and fuel cells, all of these things that they, as opposed to deploying, developing, and allowing the public to choose to take a different path, they took all this technology and mostly just sat on it. And then finally, as we know, they denied. Once the science got reasonably certain, they started saying things very differently in public than they would in private. Exxon, around the turn of the century, started publishing these advertorials, being very equivocal about what the science actually said, how certain it was, and how dangerous it would be, whereas in their private communications, they acknowledged how serious it was. They funded all these dark money groups. They funded scientists discreetly whose work had been discredited, but who didn't disclose that they were being funded by the oil industry, and the list goes on. And then finally, just one more point. They incorporated, while they were doing the denial, while they were obfuscating, confusing everyone, they incorporated their understanding of climate change into their operational planning. There are at least 2 good examples in 1986 and 1989 of Exxon and Shell, respectively, acknowledging that the Arctic, with all of its ice and permafrost, was going to physically change over the time span of the projects that they wanted to construct there, and that they needed to build that into the plans.
And Berkeley hiss. They can hear you all the way in Irving, Texas. May, I'd love to hear from you how you, from your perspective, is, and having a really sort of, view from kind of a movement leader perspective, how does this fit together with the other actions and activities we're seeing to challenge the corporate actors? So specifically, I'm thinking about the divestment campaign, the fossil fuel divestment campaign that 350 is led so wonderfully, and then also the Keep It in the Ground movement, so the campaigns against pipelines and coal trains and oil trains. How does this litigation and these now new pressure on the carbon barons and the carbon polluters. How does it fit in?
Yeah, thanks, Jason, and thanks so much, Janet, for organizing all of us here in Fossil Free California. And I just want to say, no matter how many times I hear this story, it makes me so angry every time. I can feel my blood boiling whenever this is relayed. And I think that's precisely the point, is that all of these pieces are part of the puzzle of painting the picture about what this industry has known and done. And every social movement in history has had a known villain. And I think the climate movement was a little slow in capturing this narrative in a way that people could respond and do something about. But the lawsuits are yet another nail in the coffin of making that argument, that there's another piece of evidence now about what this industry is doing, and it's starting to get at what can actually be done about it, and how can justice be done at a very fundamental level. If right now so many cities around the world are having to pay for the damages of climate change, just as you said, for a problem that they largely did not cause, at a certain point, the public purse should not be used for these expenses. There is someone who caused it, and they should pay. So I think that the lawsuits help people understand what's at stake in a new way. And I think in the climate fight, we always need new ways of doing that, because the problem can seem diffuse, it can seem complex, and I think when you start to understand who's causing climate change, who's being affected, and who is being held to account, it starts to hold together. And so in terms of its connection to other pieces of the struggle, you have, right here in the Bay Area, I think it's a really good example. You have oil refineries in Richmond, in Benicia, in Martinez, so you have community groups fighting extraction right here. You have community groups fighting the construction of a new export terminal, so not only the extraction and the burning taking place in the Bay Area, but also the process to get those products out to market. You have the city suing the oil companies, and then you have numerous other players in the Bay Area divesting. So you even, and this is not unique to the Bay Area, there's a lot of places around the world where this combination of strategies is being used. And I think it's helping the movement build political power, and I think it's helping people understand what can be done. And I think the reason it's important to have a known target or villain in a social movement is that when it comes to understanding the climate issue, we know we're all responsible individually, right? Like we know that, we can accept that. We understand that our individual actions contribute to this problem and that our individual actions can be part of the solution. But that can be so demobilizing, and that has been so effectively used by industry to get people to do nothing. And it's important to demonstrate that these are much larger systemic problems at play and big political and economic systems that have to shift. And that's also going to require individual action, right? It's going to require organizing, mobilizing, like what many of us did on Saturday. So I just want to make that point more firmly about why this is needed, because of how people can feel stuck when it comes to what they do about climate change.
So okay, we've got all these impacts, and we sort of knew that the villains and the bastards knew, right? But then how do you really apportion blame, right? I mean, how do you really, if you've got this pie of total greenhouse gas emissions from all of human history, how do we decide this part goes to ExxonMobil and this part goes to Chevron and this part goes to Shell? So I'd love it, Christina, or maybe Stephen, let's maybe start with Christina. Talk a little bit about what's now known as attribution science. Like, what does attribution science mean, and why is it so important for the cases from San Francisco and other places?
So attribution science is a really fascinating and rapidly evolving field. Just even a few years ago, there wasn't really a scientific consensus that it was legitimate. But increasingly, we've found methods and processes and models that help us to attribute specific amounts of carbon dioxide to climate impacts. So more broadly, you've probably seen some of these attribution studies when you read in the news that things like Hurricane Harvey were made 15% more likely by human-caused climate change. That without that fingerprint of human emissions, the sort of devastating rains that occurred during Hurricane Harvey wouldn't have happened. So when it comes to attributing specific amounts of warming and sea level rise to individual fossil fuel emitters, that was something that some of my colleagues at UCS did in a really groundbreaking study last year, where they built on this incredible database that a scientist named Rick Heady had developed. And what Heady did is he went into like the dust bins of all of the oil companies and all their old libraries, dug up all the records about what they had extracted. And then he was able to calculate from that how much CO2 in our atmosphere was directly attributable to the products of individual oil companies and fossil fuel companies, cement companies. So my colleagues at UCS then took that and they said, okay, this is the amount of CO2 that is attributable to these particular companies. How much warming does that cause? And how much sea level rise does that cause? So I have one more graphic, if we could just advance. Very simply, you'll see this bar chart crop up. And so looking at temperature on the in the orange bar and sea level rise globally in the yellow bar, you can see that about 16% of the amount of temperature increase we've experienced since the late 1800s is attributable to about 50 fossil fuel companies. And about 10% or 11% of the global sea level rise we've experienced in that time period is attributable to these companies. We can get even more fine-grained than that. We can distill it down to just the 7 largest oil companies. And I'm going to just peek at my notes because this is a lot of numbers. But when we look at just the 7 largest oil companies, we see that about 10% of the air temperature increase is attributable to those companies, and about 8% of the global sea level rise. So we can get really fine-grained about what portion of these climate impacts the fossil fuel industry is responsible for. And that is hopefully something that can feed into these lawsuits to say, okay, they're not responsible for all of it, right? We, as May was just saying, we are all responsible for it. And yet, as Stephen was saying, we weren't given any choice, right? And so, while yes, we all will pay to some extent, there is a need for those who are most responsible to pay as well.
You have to say it's really stunning on this second graphic. You can't totally see because you don't go out to the present, but is to think about the fact that in the 30 years since Dr. James Hansen first brought this issue to widespread public attention with his testimony in Congress in the summer of 1988. In the last 30 years, half of all human greenhouse gas emissions have happened. So it's like if we had taken action then, we would have avoided potentially half or some significant portion of all the impacts. It's just important to keep that fact in mind, that a lot of what Stephen is talking about, the deception, the obfuscation, happened even as emissions were skyrocketing. So again, this is sort of a connect the dots exercise here. So we've got attribution science. So then, Yvonne, how did your city attorney's office, along with outside counsel, how do you then take these dots and connect them and then make an argument of sort of demonstrating essentially like a tort or demonstrating, I guess, a public nuisance? I wonder if you could talk a little bit about, just in lay terms, sort of, how you then took all these dots and make a case saying, and you must pay. And what's the sort of the legal argument you use there?
So the attribution science was really important because it was able to pinpoint particular actors, right? So lawsuits, as we all know, are filed by plaintiffs against defendants, but not nameless, faceless defendants, right? They have to be identifiable and responsible. And so the attribution science assisted us in really focusing on the largest actors. then public nuisance itself, it's a very, very old doctrine. It's a doctrine that's been around for a long time. It is available to private individuals as well as to governments like cities and counties. And it essentially says that anything that is injurious to health, offensive to the senses, or interferes with what the statute says, one's quiet enjoyment. That is all sorts of different things, right? Sometimes that is housing conditions that tenants live in that have mold and substandard building conditions. Sometimes we had a very large case involving lead paint manufacturers, where manufacturers were promoting lead paint for use in residential structures. Sometimes that has to do with criminal conduct that constitutes a nuisance for a particular neighborhood or community. In this context, it is a doctrine that its agility makes it applicable here to climate change. And so, again, nuisance it's a doctrine that has to apply, that generally applies to real property, not always. And so San Francisco, because of these conditions caused by defendants, are going to have to incur costs to reinforce seawalls and deal with additional flooding. We haven't talked about this, but right, one of the consequences of global warming is also the intensity of storms. It's not a direct issue in our case, but it certainly will be something that will tax sewer and water containment systems across different cities. So we took this agile doctrine and we applied it in a new way. Again, whenever you stretch a doctrine in some way, sometimes you have courts that adopt your view early and sometimes not. It is clear that because of attribution science, that these 5 fossil fuel companies that are defendants in our case have through their manufacture of fossil fuels, have created a situation which is contributing substantially to global warming and therefore to sea level rise. And so we believe that it is those facts lead to a public nuisance. The other thing that I want to reiterate that my colleague said was the deceptive statements, right? So there were, again, our case is not one that is directly about those deceptive statements, but it certainly raises them because at the same time that production was increasing, you had denial of what scientists were coalescing around. You had not just direct denial, but kind of continuous misinformation that was informing or misinforming policy decisions that were made across the country in our different state legislatures, in our different city councils. And so that is an aspect of the case that's really important not to ignore, because it wasn't just the nuisance occurred and this was an inevitability of our post-industrial revolution. This was a calculated effort to increase production when these companies knew this was going to be the path that we were all going to be on. Unfortunately, we were all the last to know. And so now we are facing this inevitable situation. And it's not that San Francisco is seeking damages. We're not. We're not seeking damages in the traditional sense. What we are seeking is something called an abatement fund. So we're saying to these 5 fossil fuel companies, you caused this condition, now contribute to the adaptations and the ameliorations that we have to do. So help us fund this seawall that we're going to have to build around our 3 sides of our 7x7 city. So San Francisco is not looking to line its coffers with unrestricted monies. This is a case where we're seeking to have these companies contribute to the capital costs that we are going to incur to stem that rising sea level.
And just, I wanted to address it, sort of also the push and pull, the tension within public nuisance, because my understanding is that when your case was dismissed, and we should clarify, right, that though the San Francisco, Oakland, and New York suits have been dismissed in federal court, again, San Mateo County, Imperial Beach, Marin County, those states continue to move through the California state courts. But in your case, the judge dismissed your case in part arguing that the benefits of fossil fuels in part sort of offset the nuisance, right? Saying, well, it's hard to adjudicate this because also society gets a lot of good things. And so I'm wondering if you could just talk about that a little bit, about how you the challenge of making the case that the harm outweighs the benefit, or do you not even have to go there?
Well, so it's true that in public nuisance, you balance the social utility of the conduct. We were dismissed very early before we got to the merits. That was one concern of Judge Alsup. In his order, he was concerned that society has embraced fossil fuels. And so how can we hold these companies responsible for something that has been a collective decision? And why these individual companies. The other thing that Judge Alsup indicated was that perhaps this problem is too large for the courts. Perhaps it would be better to have these problems legislated by Congress rather than having a court in a particular district decide it. It's hard for lawyers to...
That's the Berkeley chuckle.
Yeah.
The Berkeley sardonic chuckle.
We have a San Francisco version ourselves. But it's hard for lawyers to accept that, right? When you embark upon something where you think that there is real change through litigation, and not only litigation, right? We work alongside all of these other strategies. There's not one strategy that's going to solve the climate change issue. We collectively have to work together looking at the problem through the lenses that we have as an expertise, whether it's a scientist or an organizer or lawyers. But it's hard for me as a lawyer to accept that a problem is too large for the courts. Because if I believed that, then I wouldn't take on half of the battles that we end up taking on, right? So again, this is the production of fossil fuels. Emissions is a different thing, but production is not something that Congress has weighed in extremely heavily on, right? And so it seems weird to defer to a regulatory structure that doesn't exist.
So speaking about sort of the larger context that the judge was talking about, Stephen, I'm wondering if you could put these cases in the context of also what's happening internationally, right? Because yes, there's these now cases moving through various state courts from jurisdictions across the country, and including some. We should point out you had the earlier map here, Christina, but they're not all coastal areas. We've got areas in Colorado soon over wildfires and bark beetles and stuff. But what's happening in other places and also overseas?
Sure. So when we started looking at this at the Center for International Environmental Law, we didn't want to focus in on one kind of climate impact or on one kind of cause of action. We really were looking for the cross-cutting legal principles that would apply in basically any circumstance. And what we found in the US and common law of torts, in the civil law jurisdiction law of non-contractual obligations, and in international human rights law, is that the question of when is someone responsible for a harm typically boils down to about three questions. First, is there a causal relationship between the actor and a harm? Did the actor know or should the actor have known that their behavior would cause the harm? And did that actor have the opportunity and the capacity to avoid or mitigate that harm? And so that framing of those questions, and this has been, I mean, we didn't invent this. This has been reiterated by the International Commission of Jurists and Oliver Wendell Holmes. But this basic frame of responsibility is where we're seeing a lot of activities that separately might not look like what we think of traditional climate litigation. And so I want to talk about three that I think make this point in themselves. First, there's a case of a Peruvian farmer named Saul Liuya. I don't know if you're familiar with this case. He lives in a valley beneath a glacial lake, and the glacier that dams the lake is melting due to global warming. And so he is suing RWE, the German utility, for only 0.5% of the cost, 1% of the cost of what it would take to shore up the glacier and install a warning system and basically ensure that his community had the ability to live. But again, premised on this idea of the attribution and the relative percentage of atmospheric carbon that RWE is responsible for. And this is really exciting because the German courts, again, this is suing a German company in a German court, they decided to hear evidence in the case. So this case is moving forward. And I think it's really important because it demonstrates both that this is not just a global north thing, not just a U.S. litigious kind of activity, but really that the global scope of the operations of these companies and the global impacts that their operations are causing will lead to liability globally, from Germany to Peru and everywhere else. Another, it's not actually a case, but an investigation that's going forward is at the Philippines Commission of Human Rights. After the devastating Typhoon Haiyan, they accepted a petition to investigate the investor-owned carbon majors to determine whether or not their behavior constitutes a violation of human rights. And this is really important. Again, this is a different kind of tribunal, but they're asking a lot of the same questions and bringing this question of climate liability out of just, again, the US tort context or the German civil non-contractual obligations context, and really into the realm of human rights, where it appropriately belongs, not instead of, but in addition to. And then finally, there are a pair of cases brought by the Conservation Law Foundation in Massachusetts that I think are really instructive, because they're climate cases, but they're not, I think it's up to 14 now of the sort of traditional damages cases include theories of nuisance and negligence and products liability. But these cases, one against Exxon, one against Shell, are premised on facilities that these companies own and operate that are adjacent to bodies of water, and were required to apply for Clean Water Act permits. And as we know, these companies knew that sea levels and storm surges would become a more significant threat to their facilities and would lead to releases of effluent and toxins greater than what is in their Clean Water Act permit. So we're seeing Clean Water Act litigation, which is fundamentally what these cases are, but premised on this issue of climate impacts and a changing climate. And so when we look at these three, the Liuya v. RWE, the Philippines investigation, and these Conservation Law Foundation cases, in addition to the, I think it's 14, but I could have that number wrong, number of cases of...
It's 12?
It's 12?
12, 13? I think that Rhode Island was 13.
13. Okay, yeah, then 13 cases of what I think are more traditional but still critical sort of basic tort damage cases. We can see that climate litigation is going to take a whole bunch of forms that we can't predict and shouldn't try to steer, and that it's not limited to this legal system, it's not limited to the few precedents that we have, and that it's growing.
So, Stephen, you said something really interesting. You said, especially in the Philippines case, it puts this conversation in like a rights-based, a human rights context. And man, I wonder if you could talk about that. Again, you were talking about how important it is to have a villain when you're doing social change work and culture change work and trying to shift the political system, but also how important it is to make sure that these suits, and if there ever are the creation of abatement funds, are assisting those and are geared to assisting those who are harmed first and worst, and how that kind of fits in with the larger climate justice narrative and larger climate justice message.
Yeah, absolutely. And another way of thinking about it is this connects to the long-term environmental justice framework of polluter pays. The idea that if you cause the problem, you have to be part of paying for the solution. So I think that's an important framework to bring in. Yeah, building a little bit on what you were saying about human rights, there's another dimension as well that we haven't talked about as much, which is the human rights abuses on the extraction end. And if you look at some of the reporting done by groups like Civicus and Global Witness, some of the most dangerous places to be an activist are places where there is a heavy amount of fossil fuel extraction. And a lot of people are familiar with Cansarawiwa and Shell, and there are a lot of examples like that in the present day. I just heard about one on Saturday. So there's lots and lots of examples where these companies are targeting activists. So we can't leave that out of this discussion as well. And I think in terms of the impacts on communities, qualifying a little bit what I said about the villain, it's not as much that we needed to create a villain. They were already there. and if you live, particularly if you live in a community next to a coal plant, if you can't get water because it's been so damaged in your community, if you have asthma, you're already living through this. And so, while we're here today, there's a Solidarity to Solutions Day of community-led solutions ideas happening in San Francisco as part of the Global Climate Action Summit. So there's a lot that's being discovered and discussed while we're here at this summit on this exact theme about what communities are experiencing, what they're doing about it, how to show solidarity and support. So I think this conversation is very tied to that conversation. And if you don't live near an extraction site and if you're not being immediately impacted by climate change, there is a lot you can do to show solidarity. And one of those things is you can organize in your community to help figure out how you can get involved in one of these cases. Because there are things that you can do as an organizer to participate. And there's people in this room who know more about that than me who could sign you up to get involved. And that's a lot of what we try to think about at 350 and in a lot of our sister and brother organizations is what are the avenues for activists to participate? And this is one very good way. I think the other thing I want to point out about the link with community organizing and what we're talking about here is the point you were making, Yvonne, about deferring to a regulatory structure that doesn't exist. I love that. I love that line. And there's an interesting component of this as well, where we've been experiencing inaction from Congress for quite a long time, predating the present administration. And so there have been lots of attempts to find other venues for action, whether it's the courts or investors, on and on and on. But while we're doing that, we're building power that could help us change Congress. So it does actually become part of a mutually beneficial cycle. So hopefully that can be part of our tool set later on because of all the work we're doing in all of these other venues. But I think that's often misunderstood, that we're doing this outside of Congress because we don't think it's good to have some kind of national policy on climate change. Quite the opposite. We're trying to build power and get that too. So wanted to make sure that that was in the conversation.
Like, if Shell and Exxon were genuinely serious about dealing with this in Congress, I'm sure the climate movement would take them up on the offer.
Absolutely.
So one thing I'd love to hear from any of you or all of you, if you want to address this, is how, if at all, it changes the conversation or changes your work and your advocacy, whether legal advocacy or grassroots or scientific advocacy, the fact that because of these lawsuits and because of a very interesting, in some ways unprecedented climate change tutorial that federal judge Alsup held earlier this spring, in which all of the major carbon polluters, the defendants, acknowledged that humans are driving climate change. Does that public acknowledgement in a court of law, does that change things now? Does it change the ability to perhaps crack through, the science deniers, or is it kind of moot?
Yeah. I would just say the thing that the oil industry is really, really good at is constantly resetting the clock and moving the goalposts, and they go from denying that it's possible to saying that, oh, it's uncertain or it's not going to be a big deal, to and this is just another stage in that shift. I think the fact that they were basically forced to admit that climate change is happening and that it's real, finally, is evidence of the tremendous work of activists, and that they were able to push the envelope far enough where it became completely unreasonable and untenable to deny. In terms of what it means for our work, I think it means we keep doing what we're doing. Yeah.
I mean, I'll say I thought it was pretty significant that Judge Alsup wanted to understand the science before ruling on the merits of whether the case should go forward. And so I would have liked it better if it was, if scientists were required to present that information rather than lawyers, as much as I love us. But I think it was somewhat groundbreaking. Now, Judge Alsup has done this in other contexts, and so it's a credit to him as a jurist to really want to understand the issues before he makes rulings. The fact that we disagree with his decision doesn't make him, he is still an excellent judge who was thoughtful. We just came to a different conclusion. But I think it was significant that he wanted to understand the science. And I don't disagree that I think this is like one permutation route. Now it's oh yes, global warming exists, but it's not just us, it's everyone. It's an international problem. Court don't deal with it, right? So that's kind of the next legal argument that they're putting forth, and that certainly was successful at least in these beginning stages in front of Judge Alsup. But I thought it was significant that he mandated that they come and that they present a case for the science so early on in a case. That is somewhat unusual. But.
So given that, yeah, the oil industry is very sophisticated at sort of the kind of dodge and pivot or the dodge and weave and saying, now they've said, yes, it's happening and yes, humans are driving it, but it's not our fault because you all bought it and you're burning it in your cars. Right. So I'm wondering, I'd love to hear from Christina or Mayor, any of you, what you think is sort of the best response to that, because I do think that's sort of the space we're at now, and as I kind of said in the introduction, you look at that Nathaniel Rich essay or kind of investigative essay, that is to some people a potent or at least a compelling argument. So what would be your response to that? That's, you know, oh, this would have happened anyway, and you all asked for it.
I think that's a great question, and I think I'll approach it from a personal point of view. So I've worked at the Union of Concerned Scientists as a contractor for many years and just started full-time with them earlier this year. And I think it was about a year ago that I was first asked to get involved in what we call our accountability work, so holding the fossil fuel companies accountable. And that's not usually my area of research, and so I started stepping into it with a lot of caution. You know, I'm not like someone who's crazy about my car or anything. I drive an old beater, but I drive, right? And, you know, we like to drive to Yosemite and we like to do this. And we are all users of cars. We all heat our homes. You know, we do all use fossil fuels. And so I came to this with a fair amount of reluctance because I was not yet convinced that this was the right approach, right? But then you start looking at stuff like that, right? And you start hearing from people like Stephen, who have documented what the oil companies knew and when they knew it. And look at how much we have damaged our earth in the last 30 years with that knowledge, right? And so I can't quite remember exactly what your question was, but I guess
how do you respond to the carbon polluters,
right?
Sort of their current dodge and pivot, which is yes, it's happening, but no, we're not responsible.
Right. So you knew where this would get us in the 1980s, and yet you denied it. You provided misinformation for decades, and you've sowed this incredibly toxic political discourse about the issue that's prevented action from Congress. And so I feel like in the past year, I've come to a point where the pieces have all started to fall into place. And I think that with this weight of evidence, there's no way we can say that these companies should not be held to pay.
Can I just jump in for a second?
Yeah, please.
I also think that, you know, speaking as a public lawyer, government is only as good as the information that it has, right? And so when you have a campaign of misinformation, you deprive your city councils, your state legislatures, Congress of the ability to take information and act on it and make policy decisions based on that. And so to the extent that there was for decades misinformation and inaccurate information and denials of what scientists were advocating from the rafters, I wonder, this is just me, Yvonne, wondering whether or not if we had embraced science 3 decades ago, whether or not we might have made different policy decisions as government that would have us in a different space right now.
Yeah, I'd love to hear your answer to the question. I also want to toss out, just also to throw in the conversation, last night there was a great 350 event in the city affiliated with the Global Climate Action Summit, and there was a young woman, I believe a 16-year-old, who got up and talked about the divestment movement or the divestment work she's been doing and pointed out that she never had a choice. She's 16 years old. Or you could say a 30-year-old born in 1988 never had a choice either, and how that maybe influences some of the work at 350 that I think is still very, in many ways, kind of youth-led and youth-centered.
Yeah, I think that idea that there has not been a choice is incredibly powerful and motivating in responding to that point that you're raising. And I think there's a few other points. One is the transition off of their product is already underway. And I think we've spoken a little bit less about that today, but the clean energy economy is doing far better than a lot of the fossil fuel companies would like and would have predicted. And it's doing better than most clean energy forecasters predicted. And so I think there is something very powerful in changing the conversation and actually saying, this is inevitable. It's a question of how quickly and how fairly this happens. And so most of the time we do like to talk about dismantling the social license of the fossil fuel industry, but I think there's incredible power in delegitimizing their product and their need to exist. And I think the other part that's important here is this is not happening in a vacuum in this country and in many other countries where corporations have so much more power now than they did even 10 years ago, let alone 50 years ago when a lot of this science was being revealed. And so we're having a debate that has so weakened government's ability to act because of the influence of the lobbying money, because of the influence of corporate power. And so it's just warped a conversation that should be about public policy making in any rational way. Like, I got involved in the climate movement because I studied political science in school. And you study political science in a way that is completely unhelpful to today's context. I wrote my thesis about the role of corporate lobbying, and I had a professor say, well, that's not really in the literature, so how are you going to write about that? So even in my short lifetime, their power has gotten even bigger, and the fossil fuel companies are one of the best examples we have of this trend and how it has warped a public dialogue. So I think that has to be part of this discussion about how the corporations frame this debate for us, and we're stuck responding to them. And I guess a better way of making my earlier point is when we talk about 100% renewable energy and we talk about the just transition, we are framing the debate ourselves. Our movement is framing it, and they have to respond to us.
So one last question for all of you before we open up to audience questions. We actually, May and I have cooked up an audience engagement thing so you all can talk to each other for a minute. But I would love you all to throw out some of your best ideas or even half-baked ideas on how how non-lawyers can get involved in this, because I think it's easy at divestment movement. It's like, go to your own bank account, your 401k, pull it out of fossil fuels, keep it in the ground, come to an anti-Keystone XL, anti-Dakota Access Pipeline protest. What can folks do who aren't working in the city attorney's office do to get engaged in this legal accountability work, this climate accountability work?
I mean, I'll limit my answer to this kind of work because I have lots of half-baked thoughts about lots of things. But I think it is it can be intimidating for people to really take ownership of the fact that their government is supposed to work for them and serve them. And I think just getting in touch with your local officials, whatever version of that is. I mean, I live in DC, so that's its own specific kind of thing. But whether you're in a city, incorporated village, or it's the state level, wherever you can talk to the people making policy, whether that's climate policy or whether it's the authority to bring or instigate litigation, just making a phone call or writing an email and understanding if they're thinking about it or what they're thinking, if they are thinking any about it, is probably a good way to start. I mean, that's my raw potato idea.
That was pretty baked. Christina or Yvonne?
I would agree with that. I would also say that, most cities have legal departments that defend the city when it's sued because someone is injured in a public space or there is an allegation that a city worker acted inappropriately. A smaller number of cities actually act affirmatively on behalf of their cities by filing cases like this. And so in addition to reaching out to the policymakers that legislate, I would also challenge your city attorneys, whether they are elected city attorneys or appointed city attorneys, to take stances on behalf of your city, to make your city as a municipal entity heard, especially on issues like this, public nuisance issues, climate change issues. There is a power in local government. We don't think of government as pushing the envelope like the advocates, but you can, often it's just either the will of the city attorney involved or the will of her constituents that can push someone into trying new tactic.
Can I ask you kind of a follow-up question on that? It's sort of an embedded assumption in your guys' point there that how important is strength in numbers? Like, how important is it to get additional jurisdictions, cities, counties, perhaps more states like Rhode Island, to file similar suits? This is sort of like a legal theory of change.
I think it's really important. I think if you look at some of the major social changes, sometimes there are a series of lawsuits that have to happen to change, and public opinion starts to change with that. You saw that in marriage, right? You saw, if you look at civil marriage litigation in California from 2004 until the present, you saw that there were a series of cases that were filed. My office filed 3 of them, and public opinion was changing with that litigation. It wasn't, we didn't do it alone. We were late to the party. Lots of people were fighting for marriage for all much before we started. But it was interesting to watch how public opinion kind of fueled the legal theories and got the courts ready to accept a major social change. So I think it's really important.
So, May, Christina, some other ideas on how folks can and should get involved?
Well, there's a couple people in this room who are helping organize elected officials all over the country to take on fights like this. If you guys could wave your hands. So if you want to learn more about what they're doing, there's a lot of work to help people who are already putting a lot of these strategies in action to learn from each other and to build the impact of the movement. So that's very helpful. And I would never underestimate the role of communications. You know, some people living in San Francisco probably don't know about California's suit, I would venture to guess. And I think that some people would want San Francisco to do more about climate change, and that Venn diagram could connect if more of us were talking about this. So part of our role as activists is to spread the word about good stories and good news that is out there. So helping to get the word out in whatever ways you can, that this is part of the climate fight, it's part of the struggle, and San Francisco is one of many cities worldwide that's doing this, is a really important thing you could all do.
And I would just add to that, that was very similar to what I was going to say, May, which is that this notion that the fossil fuel companies should pay is not something that is part of our social dialogue right now. And so simply talking about this with your neighbors and community members and getting people to start thinking about it, because I don't honestly know that it's something that occurs to everyone. And yet, when we look at where we are with the tobacco industry, for example, I think most people, with the decades that are behind us now, since the big tobacco suits were at play, could see those similarities, right? And we can see the tobacco industry as the villain and recognize the benefit of calling them out and the regulations that have since followed. So socializing this notion, I think, is a really important part of the activism that we all can do.
Well, thank you all for sharing all these great thoughts and insights and experiences. And we're going to open it up for questions from all of you so we can have a conversation. But before we do, knowing that movement building is about making connections, we'd love for you to turn to your neighbor. Hopefully it's someone you don't know, but if it is, you can skip the introduction. But turn to your neighbor, introduce yourself, and take just 2 or 3 minutes and talk about other ideas you might have, or if there's something you didn't hear from the panel, other ways that you can imagine just, again, sort of non-lawyer, but lay people, activists, citizens, engaged community members getting involved in this. And then we'll open up, and you can share if you have a really great one, come to the mic and share it, or just, again, questions. So 2 to 3 minutes, get to know your neighbors. Well, clearly that was really invigorating, and people had a lot of ideas. Do you want to get up and share them? You're welcome to come up to the microphone here. Either I'd invite you to share what you and your neighbor talked about, and/or offer some questions. Let's try in our best form to keep it to a 1-part question. and a question, that'd be ideal. And please.
I have a simple question. As I read this graph, it looks like in the last 35 years, 62% of carbon has been emitted, right? And those were those 35 years in which the oil companies were obfuscating and lying and telling people that what they knew to be true was not true, correct? How much money did those oil companies make in those 35 years? That would be a powerful piece of information for our advocacy work.
Stephen, do you have that? Have you guys crunched those numbers?
A lot.
No, I know it's a lot, but if they made $5 trillion, let's argue that they should give $5 trillion to the city of San Francisco and everyone else to abate what's happening. I don't know. I'd love to have that information.
That's a really good point, and I think it also brings up the urgency of this question of who's going to pay for climate change and why this kind of litigation is so important. Because if you look at what the oil companies are actually spending their money on, it's a lot of exploration and drilling for new oil and a lot of share buybacks, which means they are, they're not trying to advertise it, but they are giving their shareholders as much money as quickly as they can. And so because this industry is not an infinitely going concern, there is a limited window to get them to pay for the damage they've done before everyone just grabs the money and runs.
And dividends. I believe ExxonMobil is among the most
Yeah.
consistent and generous, pairs of dividends on their stocks.
Yeah.
Thanks, Alex. He's a gentleman. So when I read Judge Alsup's opinion, it really seemed to me that he was pointing us in a direction for future cases. So I wanted to see if your analysis was similar. He focused a lot on the deception piece, and it seemed that he was suggesting that the argument didn't focus enough on that, or that was considered more like the cherry on top while we were focusing on the climate damages. And he didn't seem fully satisfied with our response to the answer, what could the fossil industry have done differently and still meet the US's energy security needs? Do you feel like in future cases there'll be more focus on the deception question?
I think the deception question is, or the deception facts are important for a variety of different reasons. They may not be the strongest argument, and I have to cabin my response because we are on appeal at the Ninth Circuit. So I think I agree with you that I think he focused on that. Now, what public nuisance says is you look at, again, a substantial interference, and so whether or not those statements would have come in under a public nuisance theory anyway. I think the hard thing about Judge Alsup in that decision is that he was, the motion was whether or not the case should go forward to an adjudication on its merits. And yet, Judge Alsup didn't allow that. And so how much importance he would have put on that issue if the case was actually tried or actually litigated substantively, I think remains to be seen. We just didn't get that chance here. It'll be interesting to follow San Mateo and the other cases in California to see whether or not a state court analyzing state public nuisance focuses on that.
That's a great question.
Hi, my name's Alex. I'm from 350 Seattle, and my family's from the small island nation of Mauritius. It's a friendly criticism and a question that I have. So in the narrative around climate liability, there's, in the panel a few times it was kind of said that the people that are really responsible for this are the fossil fuel industry. It's not the cities that are responsible for causing the harms, right? And I think that's true to a certain extent. The fossil fuel companies should be held accountable for the harms that they've created, but we mustn't invisibilize how much the global north has contributed to this problem and how much cities, as the largest emitters, have contributed to this problem. And I worry that by invisibilizing that, by not talking about that responsibility, we forget the debt that the global north owes. And that's not just a theoretical worry. Trump has pulled out of the Green Climate Fund $2 billion, and the whole We Are Still A movement has not really talked about this. Seattle put out a call to cities across the country to join them in contributing, in some way, even a small amount, and no cities are stepping up to this. So I'd like to see this discourse recognize this, and I'd like to see maybe those cities who are some of the wealthiest cities in the world, some of the richest cities in the world, also think about what they can do to contribute while they also claim liability. So I think those need to go hand in hand. Thank you.
Any thoughts, responses on that?
I mean, I'll say I think it's a fair point. I would say that San Francisco in particular has mobilized an enormous amount of efforts from departments ranging from the Department of Public Works to our Department of Environment to address the issue. We're not laying all climate change at the foot of these fossil fuel companies, but in the same way that we are expending resources now to deal with the problem now, they are also they were a meaningful causer, and that's not really a word. They were a meaningful contributor, and so they should be meaningful, someone who is contributing to the meaningful remedy. But it's a good point.
Yeah, I think it's a good point too, and I think it's a good caution to not make it sound like the blame is being shifted, but here is another opportunity to demonstrate what has to be done.
Yeah, thanks very much for a really informative panel. I think and maybe based on the question, a lot of other people find that the narrative around the kind of bad action of the fossil fuel industry in terms of kind of denying facts and lobbying against climate change for such a long time, and like that's the real kind of the bad thing that they did, right? And so to what extent can we then tie these attribution statements and more specifically kind of the legal questions to that bad action? And this kind of echoes kind of a previous question too. Is there anyone out there who's exploring, I'm a little bit out of my legal depth here, but like RICO type cases around like what they were doing at the time as a kind of conspiracy and collusion and lying to the public, and holding them responsible specifically for that rather than a kind of nuisance type litigation.
Big oil is the new mafia.
Yeah, well, I mean,
Hold up.
I know there have been a lot of efforts. I don't know where anything is now, and I don't want to misstate anything, but there's been a lot of attention also paid to consumer communications or advertising laws and the way in which that the kinds of statements and the kinds of advertorials and the way that the oil companies were getting their message of obfuscation and misinformation out might be in violation of those standards. I'll also say, though, that another interesting element of this litigation is the financial litigation part of it, that these companies interact with the public, but they also interact with their shareholders. And there are a ton of corporate and securities laws that require honesty and disclosure and forewarning of material risks. And there are currently cases going now against Exxon and maybe definitely at least against Exxon, of shareholders suing Exxon for misrepresenting the value of its reserves, basically saying that they would be able to dig up and sell and overvalue these reserves. Also, the investigation from the New York State Attorney General's office is in part a Martin Act investigation, which is about financial fraud. So, short answer, yes. Yeah, there's quite a bit moving. Yeah.
My name is Glenn. I actually brought up with my city the possibility of engaging in one of these lawsuits, and the answer that I got kind of indirectly through channels was that they were scared. They were scared of financial risk they might be running, and it's a small city. So I wonder if you could maybe comment on that.
Yeah, I'd love to hear that. And Yvonne, maybe talk about what ExxonMobil, among the defendants, has done to sort of intimidate plaintiffs.
I mean, it's real. I understand the fear. It is not easy to bring a lawsuit against some of the largest companies in the world, and one of the consequences of us bringing our action against Exxon was that Exxon sued my boss, Dennis Herrera, in court in Texas, trying to hold him as a city attorney in San Francisco answerable to courts in Texas. I think that was a tactic that was designed to intimidate and punish a city from exercising its rights. Again, I said Dennis was bold, and he is, and so he was not intimidated, but we've seen this in other contexts. Cities are worried about not only the expense, but retaliation by other governments. We've seen in the sanctuary city context, cities like Miami who shy away from policies that were well-reasoned and deliberate because of threats by the federal government. This is an action that the fossil fuel companies are not embracing. And so I understand that the fear is real. I just think that sometimes one has to have a commitment to the larger issue and some courage to take these issues on. And one way that a smaller city can do that is to work with and collaborate with a coalition of cities, either a coalition of cities or come together with a larger city to bring a case together. That it might make a smaller city more comfortable in bringing that action, and it would also, it would raise the stakes and the profile of that particular case. It's something for them to think about.
And could you just, Yvonne, talk about what happened yesterday? You were kind of talking about state attorneys general investigation. So there's the New York one, but also one in Massachusetts. And yesterday, I believe ExxonMobil appealed that to the U.S. Supreme Court.
I mean, they are litigating these cases aggressively. I think that they believe that if, because there are many jurisdictions that are fighting this fight and many more jurisdictions that are affected, to lose would set in motion a chain of litigation that might not inure to their benefit. And so they have been traditionally very aggressive.
Great. My question was actually exactly on that. Can you hear me? Dominic Frangillo, former council member, Caroline, New York. And my question it was exactly on organizing elected officials. Thank you for the shout out on around climate mitigation across municipal boundaries. So just for some context, right? There's two courts, right? There's the legal court, and then there's the court of public opinion. And our experience, we're actually working with many of the cities that have elected officials that have sued, that have active lawsuits or have filed. Imperial Beach, the mayor, we have 9 supervisors that have signed on a letter to the Governor Brown to phase out fossil fuel production in the state. Benicia, Culver City, others. And how do we link together elected officials that may not have the resources, may not have the technical knowledge, may not have the political capital locally to spearhead something, but would be totally willing to go on, to go together with others. And public opinion, just for context experience in New York, for example, we organized nearly 1,000 elected officials across the state to ban fracking and push forward on divestment stuff, and that helped provide the political space for New York City to, I was talking with Dan, we're working closely with the mayor's office to make their announcements on divestment and to come out with lawsuits. So how can, I guess my question is, are there organized efforts already of elected officials beyond, or cities beyond municipal boundaries and in regions across states that are thinking about climate litigation? Is there a role for peer-to-peer organizing to help share information and so that they can all kind of, multiple ones can jump in together? Have you heard about that, or what?
I mean, there are, in California, for example, there are organizations of local governments, the California League of Cities, the International Municipal Lawyers Association, that sometimes convene specific issues, whether it's on opioids or climate change, where they share information. I think, in my experience, elected officials are very willing to collaborate and get together, and in part, it's just creating those networks and having those communications. I think there are also other ways that cities can get involved in an issue like this shy of filing, and that is filing amicus briefs, right? Being amici gets the viewpoint of how harmful something is without having to devote the resources to litigation. So those are some ideas.
Anything from Stephen or May on that?
I would just add a parallel from the fossil fuel divestment movement, which is that this does require some degree of technical knowledge, which can be a bit intimidating to get involved, but it's a very overcomable problem. And part of what I think helped divestment pick up speed so quickly is that there were some centralized tools for people about things you need to know when you meet a board of trustees and what questions you're likely to get asked. So resources like that could probably be prepared on this issue. Of course, there's specific differences in each city, but there are some generalizable resources, and maybe that's a follow-up from this event, is thinking about who could build that tool set.
Before we go to the next question, I just want to remind folks that there is plenty of other information in the lobby. Union of Concerned Scientists, perhaps 350. I've got information out there. Got copies of Sierra Magazine, et cetera. So make sure you grab those, because those are also some good resources just to start with. Just want to make sure we hit that before we do this next question.
Hi, I'm a recent law school graduate, and I was curious about sort of how this case might proceed going forward. I know there's some limits on what can be answered because it's pending, but I was wondering whether the increased access to and adoption of clean energy is relevant, whether you think it's relevant in that benefit burden analysis of the public nuisance claim, because it seems to me that there's an argument that was raised that there wasn't really a choice for a lot of people, but that increasingly people are making a choice that doesn't carry that burden and that reaps just the same benefits. I was wondering whether that's an argument that might be deployed.
I think that's an argument that it's a theme that might come up if one of these cases goes to trial on its merit. I think right now, one thing that the Ninth Circuit is going to have to settle is whether or not these cases belong in federal court or state court. Our Northern District judges, Alsup and Chabria, respectively, came to two different conclusions, which is why the San Mateo case proceeds in state court and our case is at the Ninth Circuit. From appeal from a federal district court judge. So I think one thing that needs to be decided next steps is whether or not this is global warming cases that cause public nuisance properly live as a federal common law claim or whether they live as a state law public nuisance claim. I think the other thing, and I think that emanating from that will be other issues that will frame the cases. But I think, whether or not the embracing by society of cleaner or alternate sources of energy, how that cuts, I'm frankly not quite sure. Because on the one hand, you could argue, right, that the additional information has caused people to make a different choice, a choice that they wouldn't have made when we were operating under a scheme of misinformation. On the other hand, despite those renewable energy sources, there is still a demand for the production, and we still as a society rely on fossil fuel products. And so whether or not a court, if balancing the utility of the conduct against the harm that is caused, would still, despite those embracing renewable energy, would come to a different conclusion, I just don't know. It's an excellent question.
Thank you.
Another question there?
Hey, good afternoon. Thank you very much for this wonderful panel. I was speaking with my neighbor about comparing the climate change litigation with previous litigation campaigns. One of the things that occurred to us is the urgency for speed, the need for speed. And in that connection, I was thinking about Judge Alsup's opinion and how he didn't seem to dwell on the reality of climate change. Neither was it really fought over by the oil companies, and I'm wondering if that's how much more work needs to be done to convince judges that climate change is a reality. It's not something we have to fight over in court. It can't be used to hold up litigation, and then how much more work needs to be done to take that conclusion in the courts and bring it to society and say this is now a done deal. This is now recognized by the courts, and what the value of that would be.
Yeah, I'm trying to structure this in my head. I think that I don't know how much of a difference, and maybe you all disagree, getting judges to that stage have from just getting the public at large to that level. I think continuing to just raise the urgency of what is actually happening. I know the IPCC 1.5 report's coming out soon, and it is what we expected, which is we have not very much time before things get really catastrophic. And so I think potentially just raising the level of urgency at large amongst the public will inform the judiciary as just members of the public. Although I do take your second point that the kind of threshold or watershed moment where it becomes clear that climate change is justiciable and is appropriate in a particular venue and under a particular cause of action is extremely important in really crystallizing and getting people to understand, here is a tangible thing that can be done that is perhaps less speculative than they think, and that can lead to real measurable change in terms of dollars and seawalls and sewer systems that get upgraded.
And the only other thing I would add is I'm not, the the law has certain ways to deal with matters of urgency. These cases concede that climate change is an inevitability. So I'm not sure that the court sees a sense of urgency in the way that it would see it in other contexts. That said, we're looking at, I think you'll have a ruling from the Ninth Circuit within a year or two, which is, in terms of legal battles, not that long. But again, litigation is just one tool. It's a great tool. I do it as my full-time job, so clearly I embrace it. But it is never going to be the only tool that's going to resolve this issue. All of the organizing and public education and community building that we're talking about here needs to happen while the courts are getting their arms around this issue.
Christine, I think you wanted to add something about the matter of speed.
Yeah, well, it
Urgency.
wasn't particularly about the matter of speed, but it was just about the need to have a public consensus that climate change is real and happening. We live in a country where, I don't have the exact number, but something like 30% of our public does not believe in evolution, right? And yet, that hasn't changed the fact that evolution is happening. It hasn't changed the fact in most parts of the country that we don't teach evolution, that we don't teach creationism in schools, right? So, this doesn't get to the question of how the judges in the public relate necessarily, but we know that there can be incredible action without having a public consensus, right? So, at some point, we do want people to be able to elect officials who are pro-climate action. And yet, we have a very diverse country. We have a huge spectrum of beliefs. And so the notion that everyone will be on board with this, I think, is something that I, as climate scientists, have to step back and say, that may not happen, and yet we can move forward.
And I think on that point of moving forward, we're going to move forward throughout the rest of the program. I know we got 2 more questioners, but we're out of time. You guys will be able to buttonhole these folks later and ask your question. I know we've got some final words from Janet Cox from Fossil Free California, who I think was going to wrap up here. And then again, I'm sure that May and Stephen and Yvonne and Christina will stick around for any other questions you all have. Thank you so much for being a fantastic audience. And let's give a round of applause before we hear the last words from Janet.
First, I have to announce a crisis. Bill McKibben left his hat. So if somebody finds it, we're going to give it to May or to Jane. Do you have it?
No, I don't have it, but I can deliver it.
We need to find his hat. Short of that, I want to thank you all so much for coming. This day turned out to be better than we ever expected, and we thought it was going to be great. But from this morning to now, we've come at this question of addressing climate change through various financial, legal mechanisms that everybody can have a part in a way that what I think is we're all going to leave here and in 3 hours or tomorrow, it's all going to sort of come together in our heads, and we're going to realize that there's something that every single one of us can do that will actually make a difference. Wherever you are, whatever you think about, whatever you're working on, we can do this. And this tremendous smorgasbord of ideas and the parade of fascinating people to listen to has really just been a gift. So I want to say just a couple words about Fossil Free California. We're smaller than we look, but we need to be bigger, and we need everybody's volunteer ideas. We need people who are willing to step up and run something. We also could use your money, but it's really a wonderful group of folks who are sort of addicted to the idea that we're just going to keep going because we're onto something. And what we're onto is the relationship between money and pollution and climate change. And I was in Paris in 2015, and the sort of the thing that came to me at the end of that was, this is the world against the oil companies. It was really clear. And that's where we still are, but 3 years later, the oil companies are aware of this in a way that they weren't then. They can hear us coming, and we've just got to keep at it, and we can do it. So thank you all for coming, and thanks to this wonderful panel. Go forth and join us.